Transition from rights and deadlines to consequences. In Section 11.3, we studied the inspection period and strict deadline-driven cancellation rights. Now we move into remedies. This is where every timeline we have covered becomes enforceable. Deadlines mean nothing without consequences. Remedies define those consequences. In the metropolitan Phoenix market, most disputes do not arise because contracts are unclear. They arise because parties fail to perform. The remedies section defines what happens when performance breaks down. This is the enforcement backbone of the residential resale contract. Cure period, 3-day opportunity to fix non-compliance. Before a breach becomes actionable, the contract requires delivery of a cure notice. If a party fails to comply with any provision, the other party must deliver written notice specifying the non-compliance. The non-complying party then has 3 days after delivery of notice to cure. If not cured within that period, the failure becomes a breach. This structure protects both sides. It prevents accidental breaches from immediately becoming lawsuits. Gilbert example buyer fails to deliver additional earnest money deposit required by contract. Seller sends cure notice specifying non-compliance. Buyer wires funds within 3 days. No breach occurs. Precision matters. The cure notice must specify the issue. The clock starts upon delivery. If the final day of the cure period falls when the recorder's office or escrow is closed and closing must occur to cure the breach, COE rolls to the next business day, both are open. This prevents technical defaults caused by administrative closures. Breach. Legal consequences of failure to perform. If a party fails to cure within the cure period, the failure becomes a breach. The non-breaching party may cancel and/or pursue remedies available in law or equity. For sellers, the earnest money may be deemed a reasonable estimate of damages. Seller may elect to accept the earnest money as sole right to damages. However, in specific buyer breach scenarios, seller must accept the earnest money as sole damages. These include failure to deliver required loan notices or failure arising from appraisal contingency waiver. Phoenix example. Buyer waives appraisal contingency and property appraises low. Buyer cannot obtain financing and fails to close. Seller must accept earnest money as sole damages. This clause prevents unlimited damage claims and provides predictability. Important distinction: an unfulfilled contingency is not a breach. If buyer properly cancels under inspection or financing contingency within timelines, that is contract performance, not breach. Chandler example. Buyer cancels during inspection period with proper written notice. Earnest money returned, no breach. Understanding the difference between cancellation rights and breach protects clients from emotional misinterpretation. The contract further states that failure to allow COE to occur on the COE date, if not cured after notice, constitutes a material breach. Closing deadlines are enforceable. Alternative dispute resolution. Mediation: first buyer and seller agree to mediate any dispute arising out of the contract. Mediation costs are split equally. Mediation is mandatory before arbitration unless excluded. If mediation fails, disputes proceed to binding arbitration unless either party opts out within 30 days after mediation concludes. If no arbitrator is agreed upon, the matter is submitted to arbitration under real estate industry rules. The arbitrator's decision is final and non-appealable. Scottsdale example. Post-closing dispute arises over undisclosed plumbing issue. Parties mediate but fail to resolve. One party opts out of arbitration within 30 days and files in court. The ADR structure encourages settlement before litigation. Exclusions from ADR, where court action is permitted. Certain matters are excluded from ADR requirements. Small claims actions under monetary threshold, foreclosure actions, unlawful detainer actions, mechanics lien filings, probate matters. Additionally, provisional remedies such as lis pendens, injunctions, or receivership filings do not waive ADR obligations. This allows urgent court protection without abandoning mediation, arbitration requirements. Attorney fees and costs. Prevailing party recovery. The prevailing party in any dispute arising out of the contract is entitled to reasonable attorney fees and costs. Costs include expert witness fees, investigation costs, and arbitration fees. This provision influences litigation strategy significantly. Mesa example buyer sues seller alleging breach. Court finds in favor of seller. Seller may recover reasonable attorney fees and costs. Prevailing party clauses create leverage and often motivate settlement. Professional agents should educate clients that litigation carries financial risk beyond the disputed amount. Why does the contract require a cure period before a breach becomes actionable? Answer: To provide the non-complying party an opportunity to correct the issue and prevent minor or technical non-compliance from immediately escalating into legal disputes. Why is an unfulfilled contingency not considered a breach? Answer: because contingencies are contractual escape mechanisms that, when exercised properly within deadlines, represent performance under the contract rather than failure to perform. Why does the contract limit a seller's damages to earnest money in certain buyer breach situations? Answer: to create predictability in damage recovery and avoid complex litigation over speculative or difficult-to-measure losses.